Please be seated. This is the time scheduled for oral argument in Span versus Maricopa County Treasurer. Our case number civil 12-0771. Each side has been allocated 20 minutes for oral argument. If the appellant desires to reserve any time for rebuttal, you may do so. There's a clock in the podium. The clock shows you how much time you left, including your rebuttal time. So you will have to manage your own time by watching the clock. If you run out of time, you run out of rebuttal time also. To advise you on oral argument, you should be aware that the court has reviewed the briefs, reviewed the record, reviewed cases and statutes, and conferenced this matter. So we're relatively familiar with what the record is and what the issues and the law are. In addition, you should be advised that we are both audio recording and video recording these proceedings. So when you step up to the podium, smile for the camera, and please clearly state your name and who you're representing. With that, Mr. Stoops?
Thank you. My name is Tom Stoops. I'm with the law firm of Stoops, Denius, Wilson, and Murray, and I represent the appellant, Mr. Span, who's here in the courtroom. Since you've read the briefs, you know that this is about the interpretation of ARS Section 42-18208, and maybe to a lesser extent, the interpretation of 42-18121. The facts are pretty simple. A certificate of purchase, which I'll call a CP, was sold in 1995. Subsequent to that, the CP holder, taking advantage of 42-18121, was allowed to come in and pay taxes for the years 1994, 1995, and 1996.
And those were purchased in 96, 97, 98?
Yes.
Isn't that right? And just to short circuit things a little bit, then nothing happened until 2000, except for statutory changes. Nothing happened procedurally until 2007 when the pension fund, its foreclosure action, Mr. Span tried to redeem, was told how much he had to pay, paid it under protest, and then the foreclosure action was dismissed. I assume the county then paid the certificate holder, is that correct, the pension fund? And then the foreclosure action was dismissed without prejudice, and this action was brought. Is that a fair statement?
The only thing I would disagree with on that statement is that Mr. Span did not pay to redeem. He paid under protest because his position was that there wasn't anything to redeem because it was void. That's the only correction I would put to that.
Okay.
Of course, you read the statutes, so the statutes, particularly with regard to the expiration of the CP, is very clear and states that, particularly with regard to this one, because this was a CP that was purchased before 2002, that if an action to foreclose the right of redemption is not made or is not filed before 10 years from the date of purchase, then the certificate expires and the lien is void.
Let me ask you a procedural question.
Sure.
This does come to us in a strange procedural setting, in the sense that Mr. Span brought a pro per complaint, an amended complaint, alleging all kinds of claims, rather than filing a defense or an answer or trying to prohibit the foreclosure on the same argument that he's made, that you're making. or suing the county for a separate proceeding, then consolidating it with the foreclosure action. Is it fair to say that the only claim he really was bringing, based on what you've said in your briefs, was a deck action?
I don't think he understood the nature of the claims that he was bringing. I think that it is a deck action to say, I didn't owe the money, it was void. The rest of the items that were added to that were a layperson's idea of what to put into a complaint, but that was the gist of what his argument was, and that's what his motion for summary judgment was based on.
So if we, let's assume hypothetically we reversed, would it just be a deck action?
Yes, I believe it would be a declaratory judgment action to declare that the lien was void and that he's also asking for the return of the monies that he paid under protest.
Well, that's, of course, that's the remedy, the proposed remedy. But I just wanted to make sure that all the other claims really are surplusage. It's really a relief for declaratory relief to get the money returned.
Yes.
Okay.
Now, the argument that you're aware of is that because these payments were made and added to the original CP pursuant to the special rights that you have if you're a CP holder, you're the only one that's got this right. You can step in the following year after June and pay these taxes.
May I ask you one question about this?
Sure.
Under 42-18-121, which allows a certificate of purchase holder to pay subsequent taxes, do the taxes have to be delinquent, or can the CP holder just go in and pay the taxes after, of course, they've been assessed, but before they become delinquent?
Well, they have to be, I guess, technically delinquent because they have to be beyond June of the year that they're owed.
Oh, okay, so it's the June 1, so that would make them delinquent.
Right. But because the property owner has the right to step in and make these payments and then they don't go into the CP. The primary advantage, and of course the statutory scheme makes a lot of sense, because when you buy the CP, you can't do anything with it for 3 years.
Right.
So in order to protect your position, you can step in and do this. And then at the end of 3 years, you can bring your action.
How does the 3 years protect the position?
The 3 years doesn't protect the position, it threatens the position.
No, I mean, if the CP holder buys or pays taxes on the following 3 years, that's just preventing anybody else from getting a new CP?
Sure.
In those years, is that what the
Because he
deal
then
is?
has competitors, and they may have, as soon as he forecloses, he's going to then have to pay them interest on the same obligations at whatever they bid it in at. Or he's got to step in and competitively bid. And the way the competitive bidding goes is I'll take less interest, et cetera. So then he's going to have to do that. So they give him a special right because he's frozen for 3 years to come in and pay these, and then he doesn't have to compete.
Do we know why? So presumably, the CP holder would would purchase the next 3 years and then foreclose.
Yes.
Well, do we know why that didn't happen here? Is there anything in the record?
There's nothing in the record why the CP holder held off for 12 years, but in fact, that's a pretty good indication of one of the reasons that the statute was passed in the first place. There's an awful lot of stuff out there that is 20 years old, 30 years old. The taxes on the CPs are so high that there's no
Interest.
The interest on it is so high, and the additional taxes that are accrued against it are so high that the property is worthless effectively.
Okay. And on this property, is it my understanding there were other CPs after the last purchase by this CP holder, which was in 98,
I believe
guess.
there
Other
were,
CPs issued?
I think there was another one issued, which has been redeemed, but it's not, of course, at issue in this case.
Right.
And I think this is the problem that we all face if you're a property owner and you run into hard times, is that you may get behind on your taxes, and that's why these safeguards are built in. But this safeguard was additionally built in to help the county, and the county obviously doesn't want to have property that isn't going to generate revenue, that it is so far underwater that no one's paying the taxes and no one's picking up the CPs or doing anything else with it. And so, of course, it's in their best interest to have it have a limitation on it. But now they've got kind of an interesting conflict of interest that they didn't used to have before because of the Elder Assistance Fund. Now, by statute, if somebody bids it in at 8%, and they just say, okay, I'll take 8% on my CP, the difference between the 8% and the 16% statutory maximum goes to the county and for that fund. And I'm sure that the Elder Assistance Fund is a very good fund, but it is revenue for the county, and in that sense, they kind of have a conflict of interest, and that's what they threatened my client with. The $32,000 that they were going to assess the next day was based on their right to enforce the Elder Assistance Fund, and that was going to be the difference between the bid amount on that CD and the county's skin in the game, if you will. And that's what they said. We're doing that tomorrow. You can pay $102,989 by 5 o'clock today.
Was the $102,989, did that take care of all the certificates that were on the property or just the pension fund's interest?
I don't know the answer to that. I believe it took care of all of it, but I'd be lying if I knew what the history beyond that was.
Why, I think one of the things that has mystified me, and perhaps I just don't understand this well enough, is the pension fund sued to foreclose the right of redemption.
Yes.
If Mr. Spann thought that the certificate of purchase was void and unenforceable, he could have appeared, defended, said, hey, you can't enforce that. It's over with.
Well, by the time he found out about it, he'd already paid the money.
Well, but isn't that his problem? I mean, what strikes me, and maybe there's just no way around it, is that he's essentially collaterally attacking a lawsuit that has been settled and dismissed and resolved by attacking and going after the county. And his remedy was to contest the foreclosure action, and he did not avail himself of that remedy.
Well, first of all, it was dismissed, but not, and over his protest. Because
no one forced him to pay the county any money. He could have litigated the plan's right to foreclose the right of redemption.
he didn't know there was a pending action.
I'm sorry, say it again.
He didn't know there was a pending
At
action.
some point, he's going to know about it.
Well, he wasn't
He's going to have to be sued and served.
Right,
So-
but he wasn't served until after he'd paid the money.
So what on earth would have required him to rush into the county and say, oh, after all this time had passed, saying, I got to pay this, I got to pay this.
Because they said if you don't pay it today, you owe another $32,000 tomorrow.
So he'd been letting it kind of slide because he could get by with it, not paying his taxes?
No, well, first of all, it's not true that he hadn't been paying his taxes. He's paid hundreds of thousands of dollars of taxes on this. He didn't pay these taxes until later, and he didn't let it slide. He thought that it was gone. He talked to the county saying this lien needs to be removed, and they said, not only are we not going to remove it, but if you don't pay us by 5 o'clock today, we're going to add another $32,000 to it.
Let me ask you a question. I guess that then it is in dispute whether he knew about the foreclosure case. If, in fact, we were to remand, and we agree with your argument on the construction of the statute, and the county shows he really did know about the foreclosure, is that going to be a defense? Is this just, because then we really do have a problem with isn't this an end run around another lawsuit that was resolved, if he knew about it?
Well, he made it very clear that he wasn't involved in, look, the stipulation to dismiss that lawsuit did not involve him. It was signed by the treasurer's office and signed by the plaintiff. He was not involved, and the record shows that he came in and protested it, said, I didn't know about it, I didn't agree to it, I didn't agree to this dismissal. It got dismissed. What he was told by the county was, pay this under protest. If you don't like it, you can bring an action, and his natural thought was that they'd hold the money. If they'd held the money, then there wouldn't have been a problem, and certainly it could have consolidated, but the money's already gone, the case is dismissed, and he's told he doesn't have a remedy. I don't think there's a question of fact in the record about his having been served with the complaint. I don't think that he was served with it. I think he did find out about it, of course. There's a reference to a certified letter, but actual notice of the pendency of the complaint. Heck, if I'd represented him and I'd known about a lawsuit, I would have much rather been able to defend him in that lawsuit, because then I wouldn't have been up against the county. I'd been up against an investor who was trying to foreclose on a document that was 2 years void, and that's what that person chose to do. But if it's void, and the county says, I'm going to assess you another $32,000, what is a taxpayer to do? He could have taken the chance, and he could have owed another $32,000 the next day. I don't think it's considered unreasonable to pay it under protest, particularly if you're instructed to do that. And that's not contested in this matter. Pay it under protest and bring an action for relief. And that's exactly what he did. Nobody has ever said in the record that he wasn't told that, and that's been conceded, that that's what he was told to do, and that's what he did. I don't think he can be faulted as a layperson for not following the best procedure, particularly if he didn't know about the pendency of the
I
lawsuit.
thought he was an expert in tax liens. That's what I thought he alleged here.
Well, I think that might be a dispute on the record.
I guess so, right.
The court hasn't certified him as
Yeah, we're not certifying
him
him as an expert,
Okay, all
obviously
right.
not, yeah.
The argument that's made, in addition, that was not made before the judge at the Superior Court level, in fact, they've made the reverse argument here, is that having made up this procedure, and I don't think there's any question that the county made up this procedure, that the Treasurer's Office made up this procedure of adding this additional year. You can't find active CP anywhere in the statutes. You can't find subtaxes in the statutes. You just can't find it anywhere. And the county's position is absolutely clear. It becomes part of the original CP, which expires 10 years after the purchase date. That purchase date never changed. So now the county has come in and said, well, what if we're wrong? No harm, no foul, because we didn't send it out and send out the notice.
But technically, they did make the argument. I think in the record indicates that they argued that giving notice to a lien holder of the expiration, it was a prerequisite for the closure and expiration of the lien down below.
I'm sorry.
So I think that they did preserve it, whether it's at least that's my conclusion. The question is that a sound argument?
Well, the way they did it, the way they argued it, was the reverse. They didn't say it didn't expire because we didn't send the notice. They said we didn't send the notice because it hadn't expired. That's the way they argued it, and they did cite to the notice provisions. But I agree with you. The question is their argument sound that because they didn't send it out, that it didn't expire? First of all, they make a constitutional argument. And the constitutional argument says that the statute has to be constitutional, otherwise, we presume that. I don't think...
we presume it when the language is clear.
Yes.
This is your point. The language doesn't say you get to have an extension of the 10 years by adding payment of subsequent taxes. That's really the fundamental dispute here.
Right. Yeah. And then they say it doesn't matter because we didn't send the notice out, and therefore A is inoperative, which would allow them to pick and choose which one of these CDs that they want to send the notice out on. And remember, they've got skin in the game on this because they can make a lot of money off of the difference between the bid amount and the 16%. In this case, it would have been $32,000. But what they have cited to is, first of all, in this case, it would not have been unconstitutional because there was still 2 years for the CP holder to foreclose. But we also have a statute directly on point, 12505C.
Do you have any case law that says 12505C applies to a statute of repose?
Well, it doesn't say statute of limitations and it doesn't say repose. What it says is that if an amendment of pre-existing law shortens the time limitation fixed, it doesn't say whether it's a repose or whether it's a statute of limitations. The only reason I call this a statute of repose is the cause of it's not dependent on the accrual of the action. It's not a discovery issue or anything like that. It's just a flat 10 years, period.
Right.
And so I think that statute has direct application. It's not limited to statutes of limitations. It's what happens if pre-existing law gets changed and now you've got an obsolete action. In order to, in my view, the reason that it was passed, although it doesn't say it in the statute, is to address exactly that, the constitutionality of taking away someone's rights retroactively. So if we shorten it and now your action's obsolete, you still got a year to bring the action. And so I think this notice argument, I think it's great for them to send out the notice. There's nothing wrong with it. But to say that the taxpayer still has a lien on his property that's void until they send the notice out would mean that they could wait 20 years. They could wait 30 years.
Did you find a case that says 12505 applies to statutes of repose?
I did not find a case. I didn't look for it because it didn't seem to me to be limited in scope. So this is the first time I've even thought about whether or not it would apply. I certainly think it would apply under the circumstances because you're taking away, 1 year you got a 20-year-old CP and you can bring an action, and the next year you can't. So because of, and of course they make the argument, in this case I don't think we deal with the constitutionality of it because the person still had 2 years. And in this circumstance, also the CP holder made their own determination of when they're going to bring the lawsuit because it's uncontested that they didn't get notice from the county. The county said they weren't eligible to receive notice until the summer of 2007 because that would have been the anniversary of their paying the June taxes in 2000.
But really, this notice constitutional issue, it's not an issue in this case. It's really just not an issue. It might be an issue in another case with another holder of a CP, but it's just not present here.
It's not because they still had 2 years to sue.
That's right.
So I started with that. And so unless the court has any more questions, I think I'm out of town.
You're out of town.
Okay.
You're out of town. Thank you, counsel. Mr. Palmer?
Good morning, Steve Palmer of the Maricopa County Attorney's Office on behalf of Appalese. This case involves the interpretation of 3 property tax statutes found in Title 42. They are the expiration statute that we've mainly been talking about, the foreclosure remedy statute that's important and was the basis of the Jennings-Strauss lawsuit, and the subtax statute, which also adds some issues to this case. If Mr. Span's argument is accepted, millions of dollars of CP holders' vested property rights would have become void in 2003.
Let me ask you a preliminary question. And I understand the county's position on this. If I buy a tax lien and I hold a CP, where am I going to go and find the policy of the county? Tell me where you publicize this.
They do have a website. Now, I don't know what it
Well-
was like in the 90s, but certainly the statutes would tell you in the 90s that there was no deadline to foreclose.
I understand that, but this is the county's policy and gloss on this language. Where do I find this? Where do I find notice that the county has this interpretation of these statutes? Where do I find this?
If it was not in the website, you would talk to the tax services manager, David Browning. You can go down there.
So I have to go, because I think this is a very significant point. I'm a citizen, a taxpayer, I have bought a CP. Are you telling me that other than picking up the phone and calling someone who I may not know, so I don't know exactly who to go to, there's no notice? Does the county provide notice of this policy?
There's no notice unless you inquire and become an expert in an area. It is a tricky area. Other than the public policy, the overarching policy that taxes should be timely paid.
Of course they should be timely paid, but I'm also entitled to notice, aren't I?
You're entitled to notice, but you have to do an investigation, just as the CP investors have to do an investigation.
Okay, so is it fair to say then that this policy is not something that the county really provides notice of in its website? It's just not, you have to do your own investigation to find out about it. So that's really kind of the state of the record before us on this?
I would think that's true, although I did not scan their website in 2007 or 2011 when the lawsuit started for that point, particular point.
Let me ask you a different question, and I think you're getting to this. In looking at the legislative history of these statutes, what I noted was that in 2002, the legislature first modified 4218-127 to impose a 10-year cutoff for CPs, or purchase of tax liens, that were purchased from and after August 22, 2002. So
Correct.
that was after. And then the next year, according to the legislative history, at the bequest or at the request of county treasurers who were concerned about tax liens and CPs that had been acquired years earlier, that they were clogging up their accounting and their records, the legislature enacted or modified 4218-208. I think it enacted 4218-208. And they imposed a 10-year limitation for tax liens purchased on or before August 31, 2002.
Correct.
Okay. And then a few years later, apparently because it was a little bit of slippage, someone realized they needed to modify 4218-20 to take out any type, to make it clear that was also 10 years. So in light of that history, both after August and before August 2002, how can we square that history with the county's interpretation that a purchaser of a holder of a tax lien who then pays subsequent taxes is entitled to essentially an extension of the 10 years?
The subtaxing extends to 10 years. We're looking for a reasonable interpretation of the statutes and as a whole, and the statute.
But my question is really very precise. The legislature caps 10 years on a going-forward basis for liens acquired after 2002, essentially, August 2002. And then the very next year, they impose that 10-year cap on liens acquired, CPs acquired before August 2002. And then they drive the point home again a few years later when they modify 4218-20. With that history, how can we square the county's interpretation of 4218-208?
Well, it wasn't until 2008 that they really tried to clean up the remedy statute. The remedy statute that no one has cited to you other than subsection A, subsection B of the remedy statute, in 2007, when Jennings Strauss reviewed that before filing their foreclosure suit, said this section applies to liens purchased from and after August 22, 2002.
I'm sorry, which statute are you referring to? when you say
That's
remedy statute?
4218-201.
Yes, you're right. That was modified later to remove, because initially, when it was first enacted, it referred to this section applies to liens purchased from and after the effective date of the act. Then it was modified in 2008 to say from and after August 22, 2002, and then that was removed later, a year or so later.
In 2008, it was the subsection B was removed entirely.
Right.
But in 2007, the remedy statute that Jennings Strauss or anybody else looking at would have said this section applies to liens purchased from and after August 22, 2002. The one implication is that if you have, because it talks about the 10-year deadline in this statute, 4218-201, one implication is we're not implementing that yet. If you have an older lien, you've basically got a cushion here of 5 years till 2008.
But, okay, what do you then do about the 2002 change, the 4218-127 on and after August 2002, and then follow the very next year, 4218-208, with the change that the liens are basically void if they are purchased on or before August 31, 2002?
The liens are void if you give the notice. And that was the point that I was getting to. That's an absurd
Oh,
result.
So if the county, just for a variety of reasons, just fails to give a notice, these liens can go on for 10 and 20 and 30 years? Does that square with the history of these statutes?
Yes, because that's not the practice. The county is diligently sending out the notices, and I assume the other counties can read the statute and are doing that too.
So does this mean then that a county, I'm sure they're diligent, I know you all work hard and the county does a good job, but as a federal official one time said, mistakes can be made, mistakes are made. And here, let's say there's a situation where a mistake is made and the notice doesn't go out, the liens go on, even though the statutory language is clear, it's 10 years, a cutoff?
The second part of the statute talks about notice, and it is critical because there would be constitutional violations on 2003 unless the notice
Why do we
language
care
is
about
not.
the constitutional violations? In this case, there was an additional 2 years. That's not an issue that's really before us in this case, is it?
It is an issue, even in this case, and of course you want to cover all scenarios when you interpret these statutes, but in this case, when they bought the CP, the implication was you can foreclose whenever. Are they reading the statutes for changes that are about to rip away their vested property rights? I don't think so.
They're not presumed to know the law. In other words, if the legislature came in and said, okay, this doesn't bar your action, but you've only got 2 years to do this. You're saying the legislature can't pass a statute that says, gee, we're going to cut off the time so that you only have 2 years. Before it was unlimited. You could seek to foreclose any time you wanted. And now we're telling you only got 2 years from now to do this. You're saying constitutionally the legislature can't do that?
If they give reasonable notice, I think they could. I did want to.
Well, aren't they giving notice by passing the statute?
In 2003, I don't think they gave that notice, in part because of the remedies statute was not affected. It only affected liens that were purchased after 2002.
But the statute makes the liens invalid. Senate Bill 1069, not to be confused with Senate Bill 1062 of recent note, but Senate Bill 1069 that was passed in April 2003, that's what we've been talking about. The fact sheet specifically says, and let me quote it for you. It says, county treasurers have expressed concern that many certificates of purchase on their books are decades old and cause an accounting burden. SB 1069 creates a 10-year expiration date for tax liens purchased by August 31, 2002.
Right, but the notice provisions aren't superfluous, and the statute was not passed to protect the rights of a taxpayer, and this gets into mandatory and directory language. The treasurers were looking for this statute. And if the notice doesn't go out, but that's the treasurer's problem. They're the one who sought this legislation. I did want to point out that the 12505, it would be B if it does apply. B talks about if there is no pre-existing deadline, the deadline in the statute. So C would not be correct if I wanted to get that in. It's B, not C. That would be the applicable subsection of 12505 if you find that statute to be applicable. And that does force you back into the statutes we're talking about and the deadlines within them. It wouldn't be a year, is the point, because they didn't shorten the pre-existing deadline. They created a deadline where there was no deadline, and that's what subsection B
I'm
is.
just having a hard time following the notice argument. 18208, 42-18208B says at least 6 months before the certificate of purchase or registered certificate expires. So 6 months before the date of expiration, the county treasurer must provide the notice. Okay. So we come back to the fundamental problem here, which is what is the date of expiration? And we would then look to the other statutes for the date or the subsection A, and then we'd also look to 42-18-127 for those that were purchased at a different time. And that gives us the date of expiration. Otherwise, it's a constantly moving target.
Unless you interpret the word shall as being directory, because the whole point of this statute was to benefit the treasurers, not
I
the taxpayer.
understand. The treasurer has an obligation to provide the notice. There's no question about it. It has to do it at least 6 months before expiration. The problem that we're trying to wrestle with is when is the date of expiration?
And that's where the treasurer's interpretation comes in.
That we can't find, but anyway, go on.
Subtaxing is the second fastest method of collecting taxes, other than people that timely pay their taxes. It is the second fastest method because it's June. It's
But how does that, the payment of the subsequent taxes, change the language in A that imposes a 10-year cutoff?
I think because the whole purpose of the statute was to benefit the treasurers, that they're looking for a reasonable interpretation along the line of that legislative intent. Please benefit the treasurers. Subtax liens are not the certificates that are the problem. You do not find 20, 30-year-old certificates that are being subtaxed. And that's the advantage of giving great weight to the treasurer's interpretation. So they really thought here, was supposed to benefit us. We should have some control here. If we don't get the notice out, or we purposely don't send it out because we have an active subtaxed CP,
So, forgive me, but it almost sounds like what you're saying is we mean well, but we can manipulate the expiration. And I don't mean that in a derogatory fashion at all. But it means that the county treasurers can adjust and change the expiration date based on good purposes, but nevertheless they can change it. And I'm having a hard time squaring that a level of discretion, so to speak, with the language of the statute.
Yeah, when I talked to the folks at our county treasurer, they were surprised that this was an issue. Frankly, they thought we got this legislation or suggested this legislation. It was supposed to protect us, benefit us. We are not having problems with subtaxed CPs. They're very active. The people typically foreclose them in a reasonable time. We didn't think this is what we were bargaining for or going to get, and they really were surprised at that interpretation.
The joy of legislation is you don't know what the unintended consequences that may well grow from the language. And this is apparently one. Did Maricopa County pass any sort of legislation through the board which would help the treasurer in any fashion?
I agree there's unintended consequences, and I still think that there's a major constitutional issue here, too. In the interpretation they're giving to you that the notice is totally unimportant, that would have wiped out vested rights on 2003, because a lot of certificates that were expiring in 2002, they're gone. And when I bought that certificate...
That's not the county's problem, is it?
No.
Until you're sued as a result of that, you just have to enforce the statutes as they come, and to the extent that someone is irked by that, they would raise that issue, it would get resolved, and if the legislature didn't like that, they could then again try to do something.
Right, and I was raising that as an interpretation argument, that the constitutional and the notice argument is important. One of the first statutory construction rules that the legislature has passed says, statutes shall be liberally construed to affect their objects and to promote justice. It's ARS 1211B. The subtaxed amounts do not become decades old. Only abandoned CPs become decades old. You invest on a property that's, you find out later is an EPA Superfund site. You buy a parcel, and a lot of the institutional bidders do not investigate, they blanket bid.
Right.
They get some orphan parcels. Those are really the ones that were the subject of the legislation in the treasurer's mind. They were the problem area. There's this other little wrinkle about taxes that are 3 or 4 years old being part of ACP that are wiped out. They are not decades old, they're only 3 or 4 years old, and I'm talking about subtaxing and adding those to the amount. It's a logic argument, but those are not decades old, and they would be wiped out by Mr. Spann's interpretation of this statute.
But the only issue technically that we would have to decide is whether the certificate of purchase, the lien evidenced by the original certificate of purchase, expired.
And that's what the statute says. That's why the trial court said it says nothing about subtaxes. It's the CP, and that lien specifically is focused only on liens bought at an auction. The subtax liens are purchased or paid for not at an auction. That created the ambiguity in the trial court judge's mind that they didn't really deal with subtaxes. It's almost like they forgot them completely.
Well, and so you could, we don't have to worry about it in this case, luckily. The county may well have to ultimately, but how would a CP handle the subsequent taxes if in fact there was a foreclosure on the CP?
You know, the statute's silent as to when you can subtax other than after. They have to be delinquent. It has to be June or thereafter. But there is sort of a de facto extension on a CP when you do subtax, because if you're going to wait a year and add another tax year's taxes to your CP, now you're waiting 4 years to arguably you could end up in some situations making you wait 4 years. You know, it's a minor issue, but I think they can add them at any time before they finish their lawsuit. They could subtax, and if no one else paid the taxes or bought them at a tax sale in February.
But you wouldn't be foreclosing subsequent taxes. You'd wait 3 years from when you purchased the original certificate of purchase, original CP.
We haven't
wouldn't you?
interpreted it that way because the 3-year deadline has a totally different, or the 3-year waiting period has a totally separate legislative purpose than the 10-year
understand that.
expiration.
Yeah.
So even though you try to tie those two together and say, well, they're in the same statute, your hands are tied, they are separate.
They're separate, yeah.
points. But you do typically, if you subtax the CP, most people are going to say, I'm foreclosing and I want my subtax money too.
Of course they want it.
Yeah,
And they're entitled to it. The statute's required.
And the redemption statute also requires them to pay all the subtaxed amounts.
That's right.
The notice provisions of the statute were not an afterthought. Then Senator Harry Mitchell, and this is in the legislative history, insisted that notification requirements be added.
But he never, I read the legislative history, and he never said, and it doesn't expire if you don't give the notice. He just, I mean, it's just as easy to interpret that as saying, you know, we want to make sure that the CP holders get some kind of notice, so the county's you better give it to them.
That's true. He doesn't make that last little piece, but that's the problem with just about every statute that we're looking at. There's nothing in 42-18-208 that talks about subtaxes at all. And there's going to be a defect in every statute.
But
I had one additional question, and you may not know the answer to this. It struck me a little odd that August was the date selected in these statutes. Is there something magical about August?
August is, I believe, is just when the legislation becomes effective. You know, it's
Right, it's normally, unless an emergency clause, 90 days after the legislature adjourns, but more often than not, that tends to be in September. But August, is there something magical about it, if you know?
it could be maybe the levy date.
Levy
Third
date?
Monday in August, I believe, is the levy date. That could have been the
Okay,
intention.
thank you.
Or it's a good time to go to the beach.
Well, thank you, counsel.
Thank you.
both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. With that, we stand at recess and allow the party attorneys for the next case to come forward.